Good evening, America. I'm Lester Holt. Today we look back at the landmark Supreme Court case Sullivan versus New York Times, where an Alabama commissioner sued the New York Times over libel and defamation. And then later, we'll talk about how the University of Tennessee has transitioned from a football school to a women's basketball school. In 1962, the New York Times ran a one-page ad to defend the efforts of Martin Luther King Jr. titled, "Heed Their Rising Voices." This ad was endorsed by several black ministers, even though there were many false statements in the article, such as the amount of times that Martin Luther King was arrested for his actions. Lester Bruce Sullivan, the Commissioner of Public Affairs in Montgomery, Alabama, took offense to the article and thought that there was reasons for defamations and libel.
What a beautiful Sunday afternoon. Dang it! The Buckeyes won the national championship again. Dang Astros win the World Series. What in tarnation is this?
Heed their rising voices? What kind of article is this? Wait a second, that's my police. It says they arrested 9 black students for doing a march on the state capitol? Completely false! I didn't do any of this crap. No. I'll get my revenge on the New York Times.
The New York Times article stated that 9 African-American college students were expelled for leading a march on the state capitol in Alabama. However, the students were actually expelled for participating in a sit-in, which was illegal in Alabama at the time. Once again, the article made an erroneous claim that the police padlocked the building the student protest took place in to starve the students. However, this wasn't true. Despite all this confusion, the students still wound up in jail. All of this footage is official footage from the Montgomery Police Department. He sued the New York Times because Merton Nachman, a libel lawyer, told him that he could recover against the Times. Soon after, the case went to the Alabama court system. In addition to the libel suit Sullivan filed against the New York Times, Sullivan also sued 4 African-American ministers mentioned in the ad in the New York Times. Sullivan won $500,000. The case reached the Supreme Court in January of 1964 since it discussed significant civil rights issues and included a major news outlet.
Mr. Sullivan, I'm Justice Black, and in the case Hopner v. Dunkirk Printing Company in 1930, the term malice from existing libel law is an elusive abstract concept and hard to prove and hard to disprove. I, Justice White, agree with Justice Black that a writer's possible malicious intent is difficult to identify and prove at the same time. We, the Supreme Court of the United States of America, unanimously decide in favor of the New York Times.
The court held that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials, except when statements are made with actual malice, meaning knowledge that they are false or with reckless disregard for truth and falsity. Under this new standard, Sullivan's case collapsed. Now on to a special Dateline report with Brian Williams. Yes, I know you don't trust him. About the University of Tennessee's colossal fall as a football program. From all of us here at NBC Nightly News, I'm Lester Holt. Thank you for watching, and God bless America.
So, before we do the Lego scene, I dropped everything. The whole state capitol. Yeah. Dang it.